We're going to talk a little more about that. Or you can implement what's called a living trust. So let's see how Tom and Cindy's I love you will is going to work. First of all, Tom said, when I die, Cindy, I want you to have everything. And then they said, well, when both of them are gone, we want Peter, Paul, and Mary to have everything. But that may not happen because this will didn't have any remarriage provisions in it. And Tom gave everything to Cindy, and Cindy gave everything to Tom. Well, if one of them remarries, they may leave everything to their new spouse or to someone else. Once they've given everything away, there's no guarantee that their children are ever going to receive that property. And so you may want to consider that when you're doing estate planning. Now, I'm not a divorce attorney, so I'm not trying to create any marital discord here. But all of you probably know people where this has happened. One of the spouses died, the other remarried, and the children got left out. Now, most of my clients that I meet with say, if I ever get rid of this spouse, I'm not going to get another one. Right? You hear that all the time. But it happens. Now, I did have one couple. They were a little bit different than most of those I meet with. They said, when my spouse dies, I'm going to be shopping for a new spouse at the funeral. So, for sure, we needed to put some remarriage provisions in their will. Also, what about Peter, Paul, and Mary? Let's look at our instance here and say, let's say Tom passed away first and he left everything to Cindy, and Cindy didn't remarry. She didn't change her will, but she left everything to Peter, Paul, and Mary. By the way, back to those remarriage provisions, I did have a client a couple of years ago. Her husband died. They had come in and done planning together. Second marriage situation, he had one child. They didn't have any children together. And so his will said everything to my wife, and then her will said, well, when I die, it's all going to go to his daughter. Well, guess what? About 2 weeks after he passed away, she came in and she said, I want to change my will. I don't want it all to go to his daughter. I want to give it to my brother and sister now. So it does happen. So you just want to make sure that you've taken care of that. But now let's look and see how this will work with Peter, Paul, and Mary. As I told you, Mary is the most responsible of the three. She's a CPA, but she works a lot of hours. And Tom and Cindy have heard a lot of grumbling lately from her husband, and they're not sure that marriage is going to last. But they want to make sure that their grandchildren end up with anything that Mary gets. They don't want it to go to her husband if they get divorced. And so that outright distribution to him or to her may not end up where they want it to end up. And then what about Paul? Well, Paul is receiving Medicaid and is receiving SSI because he has Down syndrome. Those are programs that are based upon his assets. And so if he inherits from Tom and Cindy, he is going to be disqualified from those programs. And he's going to have to spend all of that money until he gets down to a $2,000 limit. And then he is going to have to reapply. And so by leaving him this outright distribution, they've really done a great disservice to him. Instead, they could have left this money in a special needs trust. That money then would have been available for his care, but it would not have counted against him for purposes of SSI or Medicaid. And some of you may have minor children. If you leave property to a minor child, and that property is not in trust, you're going to have to, the surviving spouse is going to have to go to court, just like that guardianship, and they're going to have to get appointed as the guardian of that minor child. And then when that minor child turns 18, they're going to have a right to go and say, I want my money now. How many of you remember being 18 in here, besides the two young people in the back of the room? How many of you would have made good investments at 18? No, probably not. And so if you're going to leave money for a minor child, you want to make sure you leave that in a trust too. And you want to put some provisions in there that say, when you reach a certain age or when you reach some certain milestones, then we'll let you have the money. Because if you don't, when they turn 18, they're probably going to have a really nice sports car and lots of nice new clothes, but they're going to go through that inheritance really quickly. So it's very important to leave that property in a trust. And then we have Peter. Remember I told you a few years ago Peter got into some trouble? Well, the trouble he got into was he had a drug problem. And so with him receiving this inheritance outright, it's going to be very detrimental. He is going to use this money in a manner that's going to harm him. And so an outright distribution for Peter is probably also not a very good thing. Outright distributions to your heirs may fall short of your estate planning goals. They're not necessarily going to give what you have, to whom you want, the way you want, and when you want to. So let's look at another way that you can distribute property to your heirs. As we saw, you can distribute it outright and there's going to be no protection, or you can distribute it in a trust. In a trust, it's going to be creditor protected, meaning that outsiders who your heirs owe money to can't come get that money. You may have a child who has some type of drug problem, maybe just doesn't manage money very well, and so you're worried that they may end up having to file bankruptcy later on, or they may just have creditors calling all the time. They may get in a car wreck and not have enough insurance. Those people could come and get that money if it was left to them outright. But if it's left to them in a trust, it's protected from all of those creditors. It's also protected from predators. A predator might be a child. You may have a spouse who's never been able to say no to your child. And you know that if you leave them all of your money outright, they're still not going to be able to say no, and they're not going to have any of that money when they need it. Maybe self-protection. You may have a spouse or another loved one who you're going to leave money to who can't manage it like Peter, and so you need that trust for self-protection. Also, estate tax protection, Medicaid estate recovery protection. Those are all reasons why leaving property outright, leaving it in trust may be a better idea than leaving it outright to your heirs.